old Stephen Gould when I checked in the Mirror this morning, and they tell me I'm an author, sounds posh, of The Return of Breaking Law.
Give us some law, Stevie boy.
There's been a major ruling this July from the Supreme Court on how assets are to be split on divorce. The ruling equally applies on the dissolution of a civil partnership or when a marriage or partnership is annulled. What is pivotal to the split is whether the assets are non-matrimonial or matrimonial, as judges call them. Non-matrimonial assets are typically those brought into a marriage by just one of the parties. We might be looking here at, say, 50 years back editions of the Radio Times, or a bachelor's flat, or even a few million in the bank, or property which is inherited or gifted to one of the parties after the marriage. The Supreme Court has decreed for the first time that these assets should be retained by the party who owns them, and they won't have to be shared with the other party. Now, there's one main caveat to that. There can be some sharing where the needs of the other party require it. For example, the wife may have to be given some of the husband's inheritance in order to buy a home to be lived in by her and the children for whom she has the main caring responsibility. Or, another caveat, one of the parties may be awarded some of the non-matrimonial assets under what's called the compensation principle, and that can apply where they've given up valuable opportunities by marrying. Otherwise, what is shared will generally be limited to the matrimonial assets, and they're usually be shared out equally.
But, as I think you've mentioned before, it isn't as straightforward as that, is it, Stephen?
Well, you know how it is. The law likes an exception here.
And an exception there.
And an exception everywhere. The exception, which was the focus of the Supreme Court's ruling, is about matrimonialisation. And the Supreme Court approved the introduction of this new word into the legal lexicon. Non-matrimonial property can become matrimonial property and so be subject to being shared between the parties. The Supreme Court has given the green light to this happening and at the same time has made it clear that, contrary to what had been decided in the Court of Appeal, this conversion from non-matrimonial to matrimonial does not have to be applied narrowly. It may be applied where it could be proved that over a period of time the parties have shown that they have treated the asset as shared between them. Most commonly, a party who owned the family home or acquired it through an inheritance after the marriage may find that it will be treated as matrimonial property because that is how, over the years, the parties themselves treated it. A ruling by the High Court could, even should, send landlords of business tenancies off to check the wording of their leases when it comes to dealing with the insurance that's got to be taken out for the premises. Almost invariably, the insurance will be arranged through the landlord and the lease will obligate the tenant to reimburse the premium. But what if the amount of the premium has reflected commission from the insurer and paid over to the landlord's broker or the landlord itself? Well, that was the position in the High Court case where the landlord was part of the Criterion Group with a portfolio of properties worth over £4 billion and the tenant was a cinema in London's Trocadero Centre. Well, it's all down to the wording and the lease. If the wording effectively says the landlord can benefit from the commission, then that's what the landlord can do. But in the High Court case, the judge decided that the wording didn't say this. The wording provided for the tenant to pay a proportionate part of the premium under a block policy for the premises in the centre, and that was for keeping the centre insured. The judge ruled that this didn't catch the commission element of the premium. The commission didn't form part of the actual cost to the landlord of keeping the premises insured, and that ruling could cost the landlord around £700,000 to be repaid to the tenant. Well, if the decision stands, the same principle could apply to insurance premiums for leases of residential premises as well, but there any commissions are likely to be somewhat smaller. The landlord can be asked whether commission has been paid and how much, and legal advice obtained as to whether a challenge to that could result in a repayment of part of a premium to the tenant. Well, that's the good news for mainly business tenants.
Here we go. Does that mean there is not so good news or, heaven forbid, bad news?
Well, the landlord's solicitor tells me that it's the landlord's intention to seek to appeal this decision, but it first has to obtain permission to appeal from the High Court judge who decided the case or from the Court of Appeal, and the appeal's got to succeed. The decision stands, at least for the time being, and so there's no reason why tenants should not check on their lease wording and so on now. And as we say, watch this space. It's well known that a pet animal can provide companionship and comfort to individuals who have mental health or psychiatric problems. How about helping to alleviate what some find as the stress of having to appear in court? Maybe. Judges have been given guidance in what is known as the Equal Treatment Bench Book on how to deal with requests to have an emotional support animal, the focus has been on dogs, accompany someone into court for the hearing of a case. The guidance says that the individual seeking permission should provide evidence of training, particularly for a dog, along with any certificates, and explain how the animal's presence could aid participation in the proceedings. The judge should seek an assurance that the animal will not foul in the courtroom, jump up, or wander freely. The other parties in the case should be given an opportunity to object. Dog allergies would be taken into account, and no doubt lawyers would want to be confident that their erudite submissions are not going to be interrupted by constant barking. The judge might come to the conclusion that the presence of the animal is desirable, but with the individual participating, the animal by their side, not in the courtroom but remotely, say from their home. Incidentally, this is about emotional support animals and not assistance dogs. They, say the guidance, should always be admitted into court. If you are applying for social housing to a local authority, you'll find that the vast majority of authorities will apply a residency test. To pass it, you'll have to show that you have a well-established association with the area or have lived in it for a minimum period of time. Well, that can be tough on anyone desperate for accommodation because they're fleeing from domestic abuse. For them, a new law has come into force as from the 10th of July 2025 in England. The test is not to be applied to them so long as they are moving for reasons connected with the domestic abuse. Even if moving from accommodation only temporarily taken up because of the abuse, the test is not to be used. The test is also disapplied to certain care leavers aged between 16 and 24.